Good morning, everyone, and welcome to Behind the Claim Part 1, Leveraging Investigation Tools to Combat Questionable Claims. We're thrilled to have you join us for this important discussion on navigating complex workers' compensation claims with strategic investigative tools. Workers' compensation, as you all know, can present challenges at any stage in the process, and early identification of questionable issues is critical. Today, we're going to explore how surveillance, background checks, and collaborative communication play a vital role in assessing claims effectively. We'll also discuss the importance of engaging skilled legal counsel early in the process to mitigate risk, identify fraud, and develop strong litigation strategies. Our goal for this session is to equip you with actionable insights on identifying questionable claims early, utilizing investigative tools strategically, leveraging surveillance for fraud detection and resolution, strengthening communication and collaboration, and finally, navigating the legal and fraud investigation processes. Before we dive into today's discussion, I have the pleasure of introducing our esteemed speakers for the presentation, each bringing a wealth of experience and expertise in investigations, legal strategy, and fraud prevention. First, we have Chris Gutierrez, founder and CEO of Strike National Investigations. Chris is a nationally recognized investigator specializing in insurance fraud, defense investigations, covering everything from workers' compensation and general liability to SIU management and compliance. His leadership has led to numerous high-profile fraud prosecutions, earning him accolades such as the Next Gen Award and recognition as one of the top 35 under 35 in our industry. Chris holds multiple certifications, i.e. designations, including fraud claims law specialist, certified expert in cyber investigations, and beyond investigations, Chris is deeply committed to education, having founded the National Education Institute of Investigations and serving as an instructor for the Insurance Education Association. Next, we have Mr. Brent Rose, a partner at Black & Rose LLP. Brent brings extensive legal experience, having worked with Fortune 500 companies before focusing on workers' compensation litigation. He represents employers, insurers, and third-party administrators before the California Workers' Compensation Appeals Board and leads a highly successful trial strategy practice for complex claims. Brent is also a dedicated educator, providing training and seminars on claims and risk management, and is an active member of the American Bar Association and the Orange County Bar Association as well. Finally, we are joined by Mr. Adam Kirk, Special Investigator at the Riverside County District Attorney's Office. Adam has dedicated over 20 years to law enforcement, with 14 years as an investigator specializing in fraud-related crimes. His expertise spans welfare fraud, unemployment fraud, real estate fraud, and his current focus, workers' compensation claimant fraud. His investigations have resulted in over 350 criminal filings in Riverside County, showcasing his commitment to upholding justice in fraudulent claims. Ladies and gentlemen, please join us in welcoming Chris, Brent, and Adam to today's presentation. By the way, we encourage each of you in the audience to engage. Feel free to ask questions via the chat feature. Be sure to take full advantage of the expertise being shared today. With that being said, let's get started. Gentlemen, I'll turn the time over to you.
All right. Thank you, Carlos. That was quite the introduction. Wow. I didn't even realize half those things about myself, but thank you. That was quite nice. Thank you, Adam. Thank you, Chris, for joining. This is going to be great. We decided to put this together some months ago. We just felt like there might be some unspoken things or maybe some tools that people would like to know about when it comes to maybe investigation tools. Everybody is going to have a different take on what they would like to get out of investigation tools. So we're going to kind of break that down throughout this process, determining on how you feel or don't feel about maybe pushing things towards a different level or trying to do things in a different manner. So hopefully we'll be able to sort of ask any of those questions through the virtue of our presentation. And then again, if you do have questions, you might want to wait till the end, and we'll try to get back to some of those on you. We'll also be taking a few polls throughout today, so you can kind of get an idea of where everybody stands on certain topics. So with that, let's move on to the first slide. All right. So kind of comes up when you're going to question a claim. Either a claim can be accepted or denied. There's questionable issues that can arise immediately on a claim. Sometimes, you may hear from a coworker or something that, oh, I heard that so-and-so may be working on the weekends, or you just kind of hear things, or things don't quite seem right. Maybe it was an unwitnessed claim of injury and the applicant maybe had some personnel issues previously, so it may look a little suspicious. So it's those types of claims and feelings you get on issues up front. Not only can you get them later on in the claim, that kind of raises one of the, your eyebrow a little bit and causes a little bit of a red flag. So it's when you want to identify those questionable claims early and what you can use as far as investigation tools and your next steps with them. It's hard, I'm sure, for answer every question on what is a questionable claim. It's kind of one of those feelings that you can get. And there's a number of examples, but it's just one of those things where you're kind of like, something just doesn't quite seem right about this. And that's kind of when you sort of take it to that next level, right? Maybe communication has dropped off of the applicant, or there's a number of different things. So it's when you have those questionable claims that you kind of look into the next steps. So everyone knows, hopefully, there's two basic types of claims: accepted and denied. It's sort of at this phase that you want to, if you have something questionable, it might be really simple to obtain a social media background check, right? Those are becoming extremely common. Back when, I used to ride my horse to the office when I started off in this business, and we didn't have social media, things like that didn't really exist. So people weren't as sort of free-spirited, I guess you'd just say, putting their life out there. You would be surprised what people will put on social media even after they file a work comp claim. I no longer have TikTok because I think it's banned or something, but I used to get some great TikTok videos of injured workers that were really interesting, dancing and things of that nature. So it's really surprising. I think when you do have that questionable claim, rather than just going full on into a much more costly expense of different types of surveillance that we'll get to, I think it's really important to maybe just do one of those social media background checks. Now, they don't always come back. It's not always sort of the line in the sand you want to draw. A lot of people may or may not be on it. Sometimes you do get great stuff. Sometimes you don't. Just because you don't get something good on a social media background check doesn't mean that there's nothing else to sort of pursue there. So it's just a really good tool to kind of get maybe substantiate or corroborate some of your early feelings on the claim when there is that sort of questionable nature. Chris, what do you guys find when you're generally doing social media background checks, sort of that in that initial phase? Like, what is important for you to obtain? Let's just say a client says, let's do a social media background check. Let's reach out to an expert like Chris. What are you sort of looking for in that beginning part?
Couple of various things, but I think one of the first questions that we ask is the type of claim and the allegations that are being made on the claim, because that's going to dictate the avenue and the type of information that we're going to be looking for. Early on in the stage of a claim, when you're engaging some type of investigation, such as a social media check, sometimes it might not necessarily be with the objective of, building a fraud prosecution, which we're certainly going to talk about later on in the presentation. But it may just be solely just to verify the degree of the applicant's limitations. So in general, if it's like an orthopedic injury, I mean, we're looking for how active the claimant is on social media, if they have any postings on or around the date of injury that they alleged, or if it's a specific injury, then obviously that specific date. But also if it's a cumulative trauma, then we're looking over that period of time and surrounding that period of time just to see, if they're doing something like they're going hiking, they're dirt bike riding, but at the same time they're alleging some injuries with you and it was an on-witness, type of situation which makes it questionable. So it definitely, it's not a 100% hit always. It's going to depend whether, people have activity, but nowadays utilizing certain, software like social facial recognition where we can, upload a photo of the claimant if there's one, and now it can scavenger hunt the web and look for anybody, that matches those facial characteristics. That certainly helps find more of those social media profiles, especially if they're using them under a different name. Because nowadays, who's really using their real name on social media?
Right.
So
Right.
find a Batman, 37, something like that, online. On-man is, fairly common too, and it's a great tool as well early on. I mean, it's literally 70% cheaper than traditional surveillance. So that's something too that I feel not a lot of people engage in the industry, and the ones that do really do get the benefit of it, because you could do like 3 days of on-man for like the cost of one and monitor 24/7, and then you really get to see a pattern.
Yeah, that we'll get to the unmanned too. That's a great point. I think also when you're looking at a social media background check, if it isn't an orthopedic injury, for example, it's a psychiatric claim, pictures of them out with friends or things of that nature can sort of help combat those claims too, where they say, they're socially withdrawn, or, they don't go and see anybody. But if you have suddenly this mass of posts out and the famous, food pics where it looks like they're happy and whatnot, it can also help combat those sort of psychiatric claims that people make too, not just the orthopedic, right? So, but I think those are a little bit more tricky. So yeah, some of the background check stuff can show, maybe even somebody even working, or maybe, they post a video of something where they're out hiking or something like that. It's when you get those sort of things that come back on those social media background check that's like, okay, I think we definitely have something here. And so then you sort of elevate it to the next steps. And when you are going to those next steps, it's really important that you communicate with whomever the parties are that you're speaking to on the claim. That could be a risk manager, the insurance company, a TPA, whoever that individual is who's making those decisions. It's really crucial at this juncture to sort of discuss what you want to do on these next steps. That way you can determine exactly what you want to look for. I had a claim recently where we did some social media, we did some surveillance. We couldn't get anything, really wasn't much posting. I couldn't get anything on surveillance. So finally, we convinced my client to do the fixed remote surveillance, which is really good. As you pointed out, it is a more cost-effective tool. You literally put a camera across the street from their house. They do them in all types of different junctures. I don't know can't remember the legalities of how they have to be elevated or whatnot, and then you basically just get a week's worth of fixed surveillance, right? And then you can go, and then you kind of can see times or if they're doing things. And when I did that recently, it opened up a whole new world. So I don't know, maybe you could speak a little bit on sort of that new trend on that fixed remote surveillance.
Yeah, that's exactly right. I mean, you can literally, I mean, some of these cameras nowadays that, like the ones that we have, you can put them for up to 7 days straight. They have remote capabilities where it's feeding straight to the cloud as things are happening, so we can monitor in real time the activity in case, the camera is lost or stolen, then there's nothing in the camera. I mean, everything has already been secured, but I think it's a great way to especially assess a claimant's activity over a period of time, especially being that 24/7 coverage. I think though, and I'd like to gauge Adam's perspective on this a little bit, and we can certainly dive into it, later on in the presentation more, but it certainly won't be something that in itself, just remote surveillance, having somebody leaving and coming back during certain hours and it looks like they're working somewhere, it's going to be enough to prosecute. You're certainly going to have to, have more than that, but the pattern definitely helps being able to engage in mobile surveillance and document that further. Would you agree with that, Adam?
I would agree. The video is really dependent on the questions that are asked surrounding that video. So just video of them doing whatever action they're doing, it lacks context. So I need medical doctors to be asking questions, specific questions about, activities of daily living that can be compared to the video. I need claims adjusters that are asking specific questions about what they're doing, where they're going, that I can then compare to the video. Depositions, I need questions asked surrounding what is in that video. So I need something to go with that video to be able to present to a prosecutor.
Yeah, I think the fix, for example, recently had a case where we got really lucky, I guess. This person was just completely and totally gardening, moving pots and all kinds of things in the front of their house, which was incredible. But we also saw a pattern where the individual was taking somebody to and from at an exact time every day. And so then we initiated mobile surveillance with it and figured out where they're going and things of that nature. So it really sort of gave us their timeline breakdown. And also, not to devalue the importance of further background checks and medical canvases. Medical canvases sometimes, when they do those thorough background checks, medical canvases can bring up a string of locations that people may or may not be treating at. They may indicate that don't have any prior treatments, and then you find all these chiropractors that aren't work comp chiropractors, they're personal chiropractors. And so then it enables us to subpoena those records too, which is also great. So once you sort of get the surveillance of the applicant, it's sort of those things that Adam was touching on. It's like, what exact are they doing? Are they exceeding work restrictions while collecting disability? Are they being more active than they're claiming they can be as far as their daily activities? Sometimes you do get lucky and you get those gym videos, which are great. I know we all love those gym videos, but sometimes those gym videos are nothing more than somebody maybe even on a treadmill. And you're like, wait a minute, they're on a treadmill. Let's go after them. But, there's nothing that says they can't walk for 30 or 40 minutes. So, but sometimes you get some great stuff.
Brian, just to amplify on that, echo what Adam was saying is the context of what's being observed in the video. It's important, right? Because oftentimes I feel like there's a video of somebody at the gym, they're lifting weights and they're on a treadmill, and it seems like a immediate slam dunk. You got somebody doing activity, and that in itself is fraud. But it only develops into fraud based on the context of what they're alleging. And so if the medical provider is saying, this person cannot lift anything greater than 5 pounds, and you get them bench pressing and, lifting weights at 80 pounds, something like that, that is completely grossly, opposite in comparison to what the medical provider has. And now you have a material misrepresentation. But we've seen in the past where, the medical provider sees the footage and they're like, well, the gym actually doesn't make them worse. It actually makes them better, based on that injury. It's actually improving them. So it's a good thing. It's not a bad thing. And so I think it's,
Right.
Just echoing more on what Adam was saying, is the context is very important, right? What are we really looking for? What are we to verify? And then we utilize the findings to really, either verify, or if it contradicts, then you investigate for it.
Exactly. That's what I was kind of going at. It's like, it's not just like this slam dunk, put it in the drawer, lock it away, we're done type of thing. You have to look at the totality of everything that's going on in the claim and what the applicant is claiming they can or cannot do, and you got to compare it against sort of, I guess you call it beneficial surveillance. So you have this surveillance, you have this social media, you're kind of in that point where, what is it? You've determined somebody is doing things that may appear to be, whether they're fraudulent or not. I know the fraud word likes to be raised by a lot of people on a case, and it's not necessarily fraud, but it's what do you want to do next with it? And I think at this point, this is when the communication between the parties it's extremely important, right? Like, what do we have? You may have to sort of, lower expectations on what you have, right? Okay, somebody went to the grocery store. That doesn't mean that, we just fold the case up and it's a work comp fraud case, right? So there's a lot of different things, a lot of different avenues. But if you do get that beneficial surveillance, that is the point that you really need to determine with your client and the investigator exactly what you think you want to do next with it, because you can do a lot of things with that. We'll get into that. And so there's a lot of avenues that you can pursue once you have that. So I think at this juncture, it's the communication. Oftentimes, I'll tend to see investigators communicating with the client on the surveillance, and sort of sometimes we're not brought into it early enough on the communications. It's best to have everybody sort of communicating on it to make sure that what we have is right. So there's basically different types of uses now once you have this beneficial surveillance. Like, what do you want to do with it? Denied claims, it can be extremely beneficial when it comes to an early resolution, depending on the type of denial and depending on what type of surveillance is obtained. For example, the medical report or something indicates the applicant, can't do anything, and you have this video of the applicant going to a job because maybe the state denied their disability request. They're not getting paid by anybody, but they're working, right? And the medical reports are saying the person's not working, and you have some great surveillance saying the person is, great surveillance of the applicant actually working. Sometimes on those denied claims, it's best to sort of use that as, I guess, a sword, so to speak, and sort of cut off those claims early. That's where the communication with the client and what their expectations are is very important, right? Accepted claims, I think, take a little bit of a different turn than on denied claims. I tend to find that clients on denied claims tend to be a little bit more proactive in using that for early resolutions versus accepted claims. So on those denied claims, it's really important that maybe you tactically try to figure out how you want to use that surveillance to sort of cut off benefits or liens or anything of that nature. Accepted claims, I think it's a different animal. Are we paying temporary disability benefits? Is the applicant working somewhere else? Is the video show the applicant exceeding their work restrictions? As Adam was pointing out, if the doctor's saying the applicant, can't lift over, 5 pounds and can't move their arms above their shoulders, yet they're outside cutting tree limbs off and carrying away pieces of the tree, then yes, that appears to be a violation of a work restriction. And even, during deposition, what are you doing on a daily basis? I don't do anything. I just sit on the couch. I watch TV. I go to my doctor, and that you have video of them. Maybe they're like at the beach and they're going for a 2-hour walk. I don't know. There's a lot of different scenarios that can come up, but if they're involved in activities that they're claiming they can't do, obviously that's going to be really beneficial. And the working elsewhere tends to be a slam dunk. If you're paying them disability benefits, that tends to be really good. But I have a story for that in a second that will sort of contradict maybe your perspective on that. And can you think of any other things, Chris, that are sort of key in this point?
No, I think you thoroughly covered the most common scenarios.
Okay. So next question on an accepted claim is, what do we want to do? What exactly do we want to be using this surveillance? Do we want to use it for early resolution? Do we want to send it to a doctor? Do we want to use it now, maybe discuss the possibility of a fraud investigation? It's really crucial at this juncture that you come up with a solid strategic plan on what you want to do with this surveillance, because if you're using it as a fraud investigation, you certainly don't want to sort of tip your hand at this point and show the other side what you have or what you're doing, right? So you want to sort of continue down that path of trying to collect more data, talking to the SIU department in your investigation, and maybe even having them talk to the district attorney that we'll talk about later once we get to how you want to do it. So it's crucial at this point on accepted claims of, how do you want to use this? Oftentimes, clients will generally, I think, use it to send to the doctor, depending on its real value. If it's really, really good, they may use it for early resolution. But I think the consensus is to get it to a doctor to show the applicant doing these things that the applicant is claiming they simply can't do. So again, communication at this point is crucial. Different entities want to use it for different things. If you have a employer, let's say that's a high deductible employer, and this is all sort of their money's up to a certain level, they may want to try to get rid of it early. If you have maybe a public entity, they may want to use it for a different matter. They may want to use it for possible fraud investigations and whatnot. So it just really depends on the strategic plan of what the client wants to do and how the client wants to use it at this juncture, that you really need to strategize and figure out next steps, because it's crucial on what you do at this point and how you utilize the surveillance that you obtained.
Hey, Brent,
So,
let's take just a second here and do
all right.
maybe our first poll and some attendee engagement. Sound good?
Perfect.
All right, team. So I'm going to launch the very first poll here that you'll see on your screen. It is for unmanned surveillance. And the question is, how often do you currently use unmanned surveillance when red flags present themselves? Go ahead and answer that question. We're going to keep it open for a little while, and we'll be back with the statistics on that. And maybe also, in addition to the poll, team, let me read through just one or two questions that have come up so far. Is that okay?
Perfect.
All right.
Good.
So the first question is from Stephanie Rodriguez. She says, how about if the employees are exempt? I'm assuming that she was talking back when we were talking about social media investigations, etc. Do any of you have any thoughts on that question?
Wait, maybe I don't understand the question. What happens if they're an exempt employee?
Correct. That's what the question is. Yep.
You mean like somebody who exempt versus non-exempt employees? I mean, that's a little bit more of a labor issue as far as how it would impact a client. Maybe I don't understand the question.
Got it. Stephanie Rodriguez, if you want to type in some more clarification for our panelists, they definitely can take a look at that. Another question that we have was from Catalina Bird. She said, can an employee account be accessed if the account is set to private? Again, from a social media investigation standpoint.
Yeah, the simple answer is no. We're not going to be able to access accounts that are private. There's a lot of misconceptions sometimes out in the industry, certain techniques or practices to access that kind of stuff. But, amplifying a little bit further, even befriending the claimant, that's not something, that we do and that would be considered ethical. Because, it may derive out of certain behaviors from the applicant that they would otherwise not do. And that in itself is not, going to be useful and potentially can compromise the entire investigation overall. Adam, have you ever had a situation like that before where like somebody befriended a firm or something, befriended a claimant and like got some information that eventually got over to you guys?
Not exactly. When I worked welfare fraud before, we had investigative technicians who had false accounts, fake accounts set up. Then they would be able to sometimes access other people's accounts just through friending them or sending a request. But that was typically not done on every case. We can, if we want to get into a private account, we'd have to write a search warrant for that account. And we could. And we can send a preservation request to whatever social media company, whatever platform they're on. We'll freeze all of their data. And then as long as we have probable cause, we can get into those private accounts and we'll do it legitimately that way.
Great. Thanks for that input, gentlemen. I have one more question and then we'll resume with the always eloquent Mr. Brent Rose. The last question that I have for now is, what is the required time frame between the date a video is recorded and when it must be disclosed or presented?
So I'm going to get into that as far as like what you want to do with the surveillance in just a couple of slides, like when you can serve it, don't have to serve it, things of that nature. I'll kind of discuss that in a little bit. It just really depends on what you're utilizing the surveillance for. If you're trying to use it for settlement, it's one thing. If you're trying to use it to get it to a doctor, it's the other thing. But I will definitely get to that in just a second.
Awesome. Thank you, Mr. Rose. Just a quick update on the poll, team. We have about 56% of participants having responded to the poll. Right now, we've got answer number 2, sometimes, but I feel like I'm in a spy movie taking the lead at 48% right now. So for the rest of you that have not voted on that poll, be sure and make your voice heard. We'd love to hear where we're at on this particular poll. Mr. Brent, take it away.
So yes, this is in that communication phase of what you want to try to do with this surveillance. So once you obviously obtain client consent and everyone is on the same page of what they want to do with it. So oftentimes you can use it to invoke a really good nominal settlement, depending on what the surveillance is, especially if you have strong surveillance of the applicant working somewhere. That is always obviously the highlight. Earlier, I was talking about TikTok. We did a social media background check on this individual. They were saying, they couldn't work. They couldn't do anything. They were very limited in their abilities to do anything. Yet a week before my deposition, this individual was doing a TikTok video on top of a hotel, like literally like doing multiple TikTok videos. And then he was like doing videos, posting on TikTok at like raves at night, all these things. So I was doing a remote deposition, and I literally did a share screen and pulled up his TikTok after he told me what he can't do. And it was just like the attorney called me right away. So it just depends on what you have and what you want to do. But oftentimes, good surveillance early can invoke a very nominal settlement. They do have those good day arguments. Chris will probably get into that a little bit later. We'll discuss it. They all say, oh, that was just one of my good days. So multiple days on surveillance obviously helps. And then what I like to do is I like to pretend as though the surveillance I have is the ultimate sort of tool to maybe invoke a fraud claim. So I'll start my settlement discussions and set the bar very low. Like, let's settle this case for $1,000. I want to put $1,000 in their head after I serve the surveillance, because I want them to know that this isn't some sort of $20,000 settlement that's going to be involved now. It's going to be very nominal, if anything. So I like to set those bars really, really low. They may laugh at it. I don't care, but at least we're kind of in the ballpark, and they're not going to give me some demand that's really contrary to my $1,000 offer. So that's sort of my thought process on settlements when you do have good surveillance like this, and kind of utilizing it as a sword again. So this is what we were talking about as far as submitting to med legal evaluators. So the time that you obtain it and the time of the med legal evaluator can depend on how many days of surveillance you're doing, right? Like, you could have an applicant who maybe saw a doctor. Doctor says, med legal evaluator says the applicant is not permanent and stationary. The applicant needs more treatments. And so you get surveillance, very good surveillance of the applicant. You're getting continued primary treating doctor's reports that are, again, sort of painting this picture that the applicant can't do anything, yet you have the applicant being extremely active. So you may invoke some more surveillance. So as long as it's not too far in time that you're going to be serving it, I feel like you can still send it out. Sometimes if surveillance is years old or something, obviously it's stale. It's probably not going to have as much of an impact. But before you do send it to a doctor, you have to serve it on applicant's attorney. They may raise issues with the surveillance. It may not be complete. Sometimes, and not all the time, but sometimes investigators will maybe send over the good portions of the surveillance and not the whole day. So the attorneys can ask for sort of all of the surveillance video evidence that you have. If they object to it being sent to the doctor, then you can't send it to the doctor right away. You have to have some sort of maybe a discovery hearing, or maybe work something out with them as far as what their objection is and why they feel like you can't send it. But if they don't say anything, you can certainly serve it onto the doctor once you wait the requisite time of the 25 days, and you can send to the doctor. I don't like to send surveillance to the doctors before exams, especially initial exams. Maybe second exams, it's not as crucial, but during initial exams, I don't like to send the surveillance to the doctors or the applicant's attorneys ahead of time, especially if we have very good surveillance. Maybe I have a case right now where the attorney is telling me that their guy really can't do anything. He's deteriorating. And like a month ago, I got surveillance of him walking. He has these two giant huskies, and he's literally walking them around a park in town for like an hour and a half. Like, well, your guy looks pretty good to me. The dogs are pulling him along and things of that nature. So oftentimes I'll send that surveillance to the doctors after the exam. And the reason why I want to do that is because I want the applicant to go to the doctor and say, I can't do anything. I'm hurting. I'm not able to do these, and just sort of maybe lay out a little bit more of a sob story, I guess. And then I'll serve it and then to the doctors after the applicant has seen the doctor, so that it can contradict what the applicant may or may not have said. I think that is a much stronger tool. Like I said, it's a little bit different when you have a second exam of a doctor. It may be better to sort of serve it on the doctor ahead of time, because you want that doctor to find the applicant permanent and stationary no matter what, right? You just want to kind of cut off disability, cut off the applicant's benefits, let's show the doctor that this person can go back to work doing something because they're very active. And so it just depends. Again, it's communicating with your client and making sure that everybody's on the same page, and you sort of lay out all the strategies of why or why not it's good to send it now versus later.
Brent, can you touch briefly on obtaining surveillance after a mandatory settlement conference and the WCAB's general appetite in admitting that evidence? MSC.
Like after an MSC and you've set it for trial,
Yeah.
you need to list it. I mean, you're going to have to list it, and you're going to have to have disclosed it before the MSC. If it's evidence that you reasonably could obtain prior to the MSC, obviously you have to serve everything on them. And I'm assuming you've already served it on everybody and the doctors anyway. You want the doctors to look at it. You don't want to go in without a doctor taking a peek at it if you're at that phase, just kind of depending on the issues, right? There's a lot of different issues that can come up. But, as you know, Chris, if you're actually going to use it in a trial and they're disputing it, then the investigator who did the surveillance has to come down to trial and testify and sort of lay out what they did to obtain it. It's a little bit of a process, but sometimes it can obviously have a lot of value. So you've sent it to the PQME before the exam, or you've sent it to the PQME after the exam. It's really crucial that at this point, you want to make sure that you diary to follow up to get that report. Because sometimes I've seen it happen. Doctors will not respond within the requisite timeframes. And then the other opposing attorney is trying to get that doctor's report thrown out because it's not timely. So it's really crucial because you want to keep that momentum going, that you do diary to follow up on that reporting. Otherwise, it could, the entire medical could be sort of taken out of the case. Adam, Carlos, you look like you're pending a question or something. You look intent.
I'm always pending a question. Your presentation is making my wheels turn in my head.
I see a lot of stuff in the chat room. I unfortunately don't have time to read it. Is there?
No, you're good. That's why I'm here. So there are a couple of really good questions that I think might be beneficial for us to just consider here. The first question, are you able to do surveillance using drones?
That's a great question. So drones are a touchy subject when it comes to insurance claims investigations. Generally, under the FAA regulations, it's considered that if you're flying a drone 400 feet or above that, there's, it's going above that expectation of privacy kind of altitude. So, it's kind of like if you're, flying a helicopter or, a plane, you'll be able to see, from the sky what's there. Now, I think what matters a lot is whether you're doing it recreationally or whether you're a licensed, pilot with the FAA. Because then, again, you could fly a helicopter and see what's going on from above, but then it'll probably be difficult to just hover there for over a period of time. In general, we don't use drones for surveillance right now to document an applicant's activities. I think there's just a lot of gray area, and there could be a lot of allegation, as to the expectation of privacy and admissibility of that video. Usually it's more utilized on other type of investigations, such as documenting a scene of an accident, if it's outdoors, or just kind of for intelligence purposes of understanding the layout. But that's really kind of the extent of it. Adam, have you seen anything different on your end when it comes to drone utilization, or kind of the DA's appetite with that kind of,
So I've never, in the 3.5 years I've been in this assignment, where comp received video from a demand package that contained drone footage. Not once. Now, it doesn't mean that I wouldn't run with that case and use it if it was viable evidence, but I can already anticipate defense, objecting to that video in motions before it goes to trial. But from an investigative standpoint, I mean, if it's, good evidence, I'll use that, and I can use that in a variety of ways to further my investigation. It's never been sent to me.
Yeah.
I feel like that this scenario that somebody may be speaking of maybe is like flying a drone over someone's backyard or something, and people would have a reasonable expectation of privacy in their own backyard and the walls and whatnot. So I feel like that would definitely be a big no-no if that were obtained. I've never seen it either, to where any kind of drone video footage came into a case, but That's a good question.
Yeah. As a general rule of thumb, surveillance always needs to be obtained from a public vantage point. So that's the question that you got to ask yourself is, can any other reasonable person observe the same if they were here? Not from a privileged position, but just from a general public standpoint. Can any other person do the same? And if it has this similar question has came up sometimes in the past where, hey, what if somebody's working out in their garage and the investigator's on the street and it's filming them working out in their garage? Is that video admissible because, it's inside their garage, so technically it's within their property, they have an expectation of privacy. Well, if the garage is wide open and anybody else from the street can see the same thing too, the trash man, the mail person, everybody else walking by, then it's free game. They're making themselves accessible. They're putting themselves in a public view. Therefore, that video can be legally obtained and admissible. And I don't think anybody will object to that. But when it comes to drones, like Adam said, maybe good stuff, but I could foresee as well all those motions being thrown to try to exclude the evidence, especially if it's damaging to them.
Yeah, I couldn't agree more. I had a case recently where we got video. The guy was working. He had like a lift in his garage. He was working on his Harley and doing all kinds of stuff, but it was within the view of the public. We certainly didn't do anything other than film into his garage. I know that it's his home and there's an expectation of privacy, but not when your garage door is up, right? So that we were able to really mitigate that case. But that's a good question.
Thanks, gentlemen. Appreciate it.
Yeah. All right. So now we're probably going to get to the phase of where the really smart people in this conversation, Adam and Chris, can start talking a little bit about, sort of those next steps. If we are going to be pursuing a fraudulent case, we think that there is enough there for fraud, then this is where you really start talking, maybe not to the district attorney's office yet, but the SIU investigator and your client, and then you're sort of breaking down, how you want to utilize this and how you want to, how you want to see it play out, right? Because it's certainly not an easy road. It's certainly not a quick road. So it can certainly delay a lot of things on your case. But if you are, you feel as though you really have a very strong issue here, and you want to take that next step, this is when you sort of decide to utilize this surveillance for a fraud case. And I think when you're utilizing that aspect of a work comp case that you do want to put together a more fraudulent issue or packet, so to speak, to the district attorney's office, you're not really revealing your information yet. You're not tipping your hat. You're not serving it on the other party. You're keeping it and you're utilizing it now at this next phase of the case that we'll get into on sort of what you do. So it's still hush hush. You can't reveal anything to anybody. And so you have a lot of stuff you need to do behind the scenes at this point.
Yeah. Well, once a matter comes over to SIU for suspected fraud or it's questionable and there's, it's believed that the fraud is at play within the question, one of the first things that we start doing as an SIU, firm is analyzing the totality of the information that has been gathered up to the point that is being referred over to us. And generally it starts with assessing the four main elements of what constitutes insurance fraud and seeing if those elements are present or there's indication of those being present. Those four are whether this applicant, filed this claim with knowledge and intent to defraud the insurance company, whether there was any material information that was misrepresented during the course of the claim process, whether the person financially gained or potentially financially gained during this process, and obviously identifying them as the perpetrator. Like we touched early on in the presentation, sometimes what we typically see a lot is an applicant files a claim, but they're alleging that, they were working and they injure, let's say their back, and they can't, they're in so much pain they can't be working. Then, they go to an industrial clinic, the industrial clinic puts them off work, saying, yes, they cannot perform the activities that they would perform at work. And then, the employer and the TPA and the carrier is like, all right, let's get surveillance on this person. Let's see what they're doing. Then, okay, we do surveillance and then, we get them going to the gym, maybe walking out a treadmill and, maybe a Stairmaster. Those things are brutal. And it seems like a slam dunk, right? Okay, we got this person at the gym. The minute they walked into the gym, it's a slam dunk. I got them. They're working out and they apparently cannot work out. Well, that in itself doesn't constitute, material misrepresentation. We have to still engage the medical provider and really understand what is it that they can and cannot do specifically, and what was it that they said that they can and cannot do, right? Sometimes, and I'll let Adam amplify this a little bit more here in a second, but we find oftentimes that, sometimes it's not the applicant itself making the statements that they can or cannot do a certain activity, is the doctor saying that. And then when we interview the applicant, we say, can you lift, more than 30 pounds? Yeah, I can, but the doctor's saying I can't. So therefore, I guess that's on my medical, my work status, but I can do it. Okay, well, the applicant itself is not misrepresenting the information, is the doctor putting those restrictions on them. Therefore, them themselves, are they really committing insurance fraud or not? Are they really misrepresenting that information? What's your take on that, Adam?
So going beyond work restrictions, you're right, Chris, it's not fraud. So that is the doctor setting those work restrictions. Just because the applicant is exceeding those work restrictions, they're just not following their doctor's orders, but they may not have ever made a statement as to what they can and can't do, or maybe the doctor wasn't specific with them about it. And so it's really incumbent upon the medical providers to be asking, what can you do, can you not do? And then from the investigative standpoint, when we go and interview those doctors, and we will interview every doctor that is relevant to our fraud investigation, we'll ask them, okay, if it's not in the medical report, why did you put them on that type of work restriction? Why did you tell them that they cannot lift over 10 pounds? What did the applicant tell you that would cause you to place that work restriction? And then so we can flesh out more of the report that may not be in the report, in the medical report. And so then once we compare surveillance video, and we'll show it to the doctors and say, well, this applicant is doing all of these things. Now, they may be beyond the work restrictions, but if you had known that the applicant could do these things, would you still have given those same work restrictions? And if the doctor's willing to say, well, no, I wouldn't have set those specific work restrictions. I didn't know the applicant can do those things. Now we're starting to get into material lies.
Yeah.
Adam, when you're investigating, I'm just going to call it a work restriction fraud case, right? Like there's other types of fraud cases, but in work comp, a work restriction fraud case like that, how many times or how percentage wise, are you going and talking to the doctors on those types of cases? Is it every one of them, or?
So I can tell you, if the referral comes to me and it is strictly the applicant is observed working beyond their work restrictions or doing activities beyond their work restrictions, and that is the only information that the SIU provides in their referral, I'm not even going to work that case. I need something more. So some specific lie, because there is no lie contained in there. There's no indication the applicant lied at all. Now, if the applicant is doing something, some type of work or activity beyond their work restrictions, but the referral will say, the applicant represented that they weren't working at all, told Dr. So-and-so that they weren't working and have not worked since the date of injury, or have not lifted anything since the date of injury. Now I have specific lies. And if I have specific lies, I am talking to every doctor about those specific lies.
Now, if you go and speak to those doctors on those cases, is there a concern that your investigation, the doctor may reveal it to the applicant, or how does that work?
Not a concern, an expectation that they might. And so there are doctors where I've spoken to doctors during an investigation in which the claim was still ongoing. And I've instructed those doctors, I would appreciate you not divulging that I was here. It would, somewhat interfere with my investigation, but I have no control over them. And so some of these doctors have, in fact, spoken to the applicant shortly after I was there. Some of these doctors removed themselves from treating the patient after seeing the evidence that I had, which was beneficial to my investigation. Some have handed my business card directly to that applicant the next time the applicant was in for their medical evaluation. And now that applicant knows that, and I don't want the applicant to know that I'm investigating them until I'm ready to speak to them, but I just have to deal with that when it happens.
Yeah, and sort of going on what you're speaking of, lifting, work restrictions and what they can or cannot do. This is when it's crucial that you interact with maybe not even the district attorney at this point, maybe the SIU investigator, and you just literally get very detailed questions at deposition. How much can you lift? How often can you lift? Why can't you lift this? What hurts? How long can you walk? You can only walk 10 minutes. What about on a good day? What if you're taking medications? Like if you take Advil, can you walk 30 minutes? So it's really on this work restriction cases, I guess, so to speak, like asking those very, very, very detailed questions is crucial, because once you get that applicant, saying this and it's clearly contradicted, then it's a lot easier, I think, for your office to sort of run with that case, because it's hard for them. You sort of backed them into a corner and now they're like, uh-oh, now what would I do? So I'm sure that really helps you all on those types of cases.
Yeah. And just to amplify it on that, Brent, one of the things that we usually recommend early on when it is a matter that, it seems questionable and the employer, the TPA, the carrier believes that there's some type of fraud being committed in the claim, but then we see that nobody has ever even interviewed the applicant. It's all based on documents and it's all based on, work status reports from the doctor. That is the first thing that we recommend, even before even engaging in surveillance, to say, we gotta talk to this person. We gotta get a statement from them, if possible, recorded, sworn statement, and get to talk to them and get them to tell us what they can and cannot do. Very specific, right? Not in general, vague terms. I always reference a case from a while ago where the applicant said, well, I can no longer do the things that I used to love doing before. And that particular attorney never amplified on that further. And then surveillance was obtained of him, at a party dancing with his wife. Well, who said that he loves dancing with his wife, right? Like he just said he can no longer do the things that he loves doing. That's very vague. So it has to be very, very specific. And then once they tell you what they can and cannot do themselves, what a good day looks like for them. Hey, do you have any good days if you're taking medication? And yeah, when I take ibuprofen, my pain goes away. Well, what does that look like for you, right? What are the things that you can do when you take ibuprofen? How frequent do you take it? All that stuff, so that then we can refute that allegation of, oh, this was a good day, if we get surveillance of them, acting beyond those limitations. And then once you get that statement from them and you're very detailed, then you go and then you start verifying all those alibis, right? Now you engage surveillance. Okay, can they lift more than 5 pounds? Like they told me they cannot do. And then you see on the surveillance that, yes, they can do that. Best type of surveillance is around a medical appointment, right? If they're going to see the doctor, let's say on Thursday, you do Wednesday, Thursday, Friday. And then you get to see what they're doing the day before. You get to see them, in the morning heading to the doctor. We had one that would ride his bike, and right outside the doctor's office, like a block away, he would put on his arm brace and then he would walk inside with his arm brace, barely moving the arm, see the doctor. He was telling the doctor that he couldn't move his arm at all. And then he would walk about a block and a half away, take it off, and then ride his bike and then do that. And then when the doctor saw that, even the doctor was upset. Wait, this person's doing that right outside my office? Man, what the heck is going on? So, and that was a, kind of, not the usual thing that you see, that somebody would just grossly behave that way. That obvious, but it's just really understanding their material statements and then going from there to verify it.
Yeah, and it's also very, very important when you do get this type of deposition testimony from an applicant that you get a wet signature signing, certifying the deposition. That is crucial. Sometimes they don't like to do it, and it's hard to sort of push them. Hey, look, we formed a stipulation. Your client needs to review, correct, and sign under penalty of perjury the depo transcript. And sometimes, they'll be like, why? So it is crucial that you do get wet signatures on those transcripts from the applicant certifying it. Adam, sorry, I didn't mean to cut you off.
No, I was going to say, to touch on that, we do appreciate the sign transcripts, so we can charge the perjury charge. We will still file and charge on the attempt perjuries when they don't sign those transcripts. I can think of maybe one case in the past 3 years where I had an actual signed transcript. But we'll still file the attempts. The judges tend to get confused as to why we're filing the attempts. So it helps to have it signed. And then to touch on the other thing about video, the more video, the better. And so if they're going to go with the defense of, I was just having a good day that day, if we have multiple dates of video that contradict the one time or two times that they're in the doctor's office, showing they're good when they're outside the doctor's office, and they only seem to be injured or incapable of doing things when they're at the doctor's office. That's just going to paint the picture that they're doing something, but inappropriate. Contrary, yes, exactly.
Yeah. So yeah, it's crucial at this point too, that once everything is obtained and you've got everything, this is when the SIU investigator sort of takes it, and then they take the ball and they take those next steps to the district attorney's office. Don't expect anything to happen overnight. Individuals like Adam are very, very busy. They have a lot of work. They got a lot of stuff going on. So not everything happens maybe as quick as you want it to happen, especially as quick as maybe some people like to get emails responded to. Just kidding. Yeah, so it's crucial at this point that you get everything together, put a nice packet together, and then you send it off to the district attorney's office through the SIU department. And then they're going to sort of look at the weight of the evidence at this point. And Adam, I'll let you sort of align with like what sort of weaknesses are there that you want people to try to avoid maybe.
So I'm just trying to think of cases that we would reject off the bat. So ones that we're seeing FD1s that come in that we're going to send right back to the SIU would be ones that either don't clarify jurisdiction or don't specify that jurisdiction is in Riverside County. We have to have some nexus to Riverside County. Now, if they're seeing multiple doctors all over Southern California, we will work cases as long as some small part of that case occurred in Riverside County. So if that's not in there, then we're going to send it back. We're going to send other ones back that only talk about what the red flags were, but they don't specify the actual material lies. You need to spell it out for us and put on there, it was a lie told to this doctor. This was the representation made to the doctor, and this is the evidence that contradicts that. What you put in the FD1 is something that we should expect to see when we ask for the entire claim file. And sometimes, SIUs can get very creative and write very well and dress up these FD1s a bit to get us to bite, and then we'll ask for the claim file, and then what we end up getting as far as evidence is not what was necessarily put in the FD1. So just make sure what you're putting in the FD1 that you're able to back that up with actual evidence that supports it.
Right.
Can you talk a little bit more for the audience on jurisdiction and the importance of that? So for touching on workers' compensation, let's say the injury happened at a warehouse in San Bernardino, but the employer has their headquarters in Riverside, and the claim was actually filed in Riverside. They walked inside the Riverside, headquarters, and that's where they actually made the representations of, the alleged injury. In your general experience, would that be Riverside jurisdiction? Or would that be San Bernardino jurisdiction? Is that kind of a shared jurisdiction? How often are you kind of seeing that type of scenario?
So jurisdiction will depend on just where the lie was told. And so if this is a causation case, if they get hurt in San Bernardino County, but they go to the Riverside headquarters and submit all of their paperwork, and that paperwork includes an employee statement that, or a DWC-1 that says this was, the way that I got injured, and they turn it in Riverside, we can argue that the lie has been told in Riverside. So it's wherever the lie is actually told. So I just had a case where the doctor visits were all in Orange County. And this was a case that I think Orange County rejected for whatever reason. They didn't want to work it. But the medical provider was in Orange County and saw the medical provider multiple times. Yet there was an interview done by the SIU, by a private investigator that went to the applicant's home and did a long, detailed interview. Of course, this applicant wasn't represented, but did a long interview and locked this applicant into multiple lies about their ability to work, if they had been working. I think it was like an hour and a half recorded interview in the city of Moreno Valley, which is in Riverside County. So based on that one day, the one interview allowed us to open a case and work it and file it in Riverside County.
That's interesting.
Wow. Even though 90% of it was done in Orange County, but we were able to still file.
Yeah, that's interesting. So at this phase, after everything's been submitted, the district attorney's office will generally contact the SIU investigator or even the defense attorney or both. And they want to maybe, if there's certain things that they want to sort of re-examine, maybe interview some of the people who may have made statements and stuff. So it's really important that This is sort of an ongoing aspect from our perspective to make sure that you retain the contact information and you sort of have everything, especially if there's like witnesses at work or things of that nature. It's really important to sort of continue to have that information because, I mean, Adam, percentage wise, how many cases you also always have follow up with, you know, the investigator or the attorney on the case is generally always, is that correct?
Yeah, so I will Prop 115, which means I will interview every single witness myself so that I can testify on behalf of all of those witnesses if this case were to go to preliminary hearing. So every prelim that we do, we don't bring in a single witness. We don't bring in the SIU. We don't bring in the claims adjuster or the doctors. I testify for 10 to 15 different witnesses. So I have to talk to everyone. And these prosecutors that file these cases trust that when and if this goes to prelim, that I'm going to be their only witness and I'm going to be able to testify. But it means I'm talking to a lot of people, and I am re-interviewing some. It is helpful to know who all these witnesses are. Typically, what I'm seeing is, you know, the doctor will work at, you know, this hospital, but some doctors work at multiple hospitals. Just, you know, do the best you can with maintaining contact information. But I would say about 50% of the time, I'm going to those doctors' homes on the weekend to interview the doctor because that's the best, you know, place and time for me to find them.
Yeah, makes sense. So one of the things that came up in one of my cases, I've had 3 prosecutions now, successful prosecutions, so good for me, I guess. But one of them was a temporary disability fraud case. The applicant was collecting temporary disability from my client. She was going through like some sort of divorce with her husband. I had these detailed questions. We had surveillance of her at this place, this T-bar, I think it was, clearly working, got her outside, moving tables, putting tables up, but she wasn't violating her work restrictions. Her work restrictions were fairly high, right? But her job with my client was a fairly arduous job. So the doctor said she couldn't do that job, but she could do other things and whatnot. So she wasn't really violating her work restrictions, but we were getting her on temporary disability fraud because she's working and collecting disability. It was really interesting that came up during the deposition. She said, well, I volunteer. I don't work at the tea place. I said, well, you don't work there? No, I just volunteer. I'm like, okay, what does that mean? So she tried to make a claim that it was her husband's store and she worked there for free. So if she worked there for free, there was no temporary disability fraud because she's not collecting temporary disability and earnings because she wasn't violating work restrictions. So what we ended up doing on that case was we ended up subpoenaing her bank records, her personal bank records, and it substantially was showing she was making weekly deposits from the tea place into her bank account. So that was ultimately the way that they were able to prosecute her and then go after for restitution. So just because, again, you have somebody that looks like they're working, it's not always a slam dunk. There could be some small caveats that you really got to make sure that you're sort of looking at all the angles.
Adam, I know you and I have talked about it, you know, several times, malingering versus causation and, you know, the practicality of prosecuting, you know, causation versus malingering case. Can you touch a little bit about that as to what the DA's office obviously needs to see to be able to prosecute somebody for a causation matter versus malingering, which is kind of the majority of the time. So, you know, what's happening?
So causation cases are incredibly difficult, and that just is from an evidence standpoint. And so while we need some sort of solid evidence that goes beyond a he said, she said, where, you know, different witnesses, their memories can be unreliable. And so everyone could have seen things differently if they saw anything at all, right? A lot of these are unwitnessed cases or unwitnessed injuries. So for causation, very much dependent on, is there some sort of surveillance video at the workplace that captures something that is contradictory to what they represent was their injury. And even that, there are difficulties with that because I've had several cases where the video is obtained, but then after the fact, the claimant will say, well, you know what, I reported the wrong day. I meant that it happened the day before the video that you got. And so by that point, that video is usually long gone. So these businesses don't retain video for that long. And we're not getting these cases for a year to 2 years, sometimes after the fact. And so from on the front end of it, the SIUs, the ones that are out there collecting this evidence, we are so dependent on you to anticipate these defenses, especially on causation cases, to where if the applicant has reported the injury happened on a specific date and there is surveillance video, for one, get the entire day's worth of surveillance video. We don't want to get into an issue of, oh, well, you only pulled, an hour and a half of video and it happened 5 minutes before that. I just had a case with DMV where and she was just convicted, where the applicant said, I hurt myself on this particular day. It was near the end of my shift. And good on I may have been DMV employees or maybe a private investigator that pulled the video and backed it up 90 minutes before the end of the shift to show this is what was going on in the 90 minutes preceding the injury. And then, as you can see, there was no injury or nothing happened as the applicant described. So by the time I went in and interviewed the applicant, the suspect in this case, and we sat down and I showed her all the surveillance video and asked her to point out to me when in the video she gets hurt as she described in her paperwork. At the end of the video, she said, well, it must have just happened right before that video started. And I had no other video to show because it just wasn't collected. So if all of that video can be collected, if possible, the day before the incident or the day after, the days surrounding, that will help strengthen our case. Now, we were still successful in that case for a variety of other reasons, but the causation cases really require a lot of work done on the front end. As opposed to the malingering cases, if you guys just put in the time and effort and get a lot of good video, I get video that surrounds the time of medical appointments, understand that video that kind of kicks off the date as far as when the fraud occurs for us. And so they could be seeing doctors for a year before the video is captured. Now, that year of doctor visits before the video is captured, we can't really do much with it because we know as of the date of the video, this is their condition. And so every date after that video, we can then move forward with prosecuting those dates. So there's often times where we lose out on a large sum of restitution because we just couldn't go back far enough because the video didn't start until much later.
Yeah, I think causation fraud is always really difficult. Those are the ones that employers are probably the most hyped up about. This is fraud. It didn't happen, but proving those up are always extremely difficult if you don't have something, it's just, those are hard.
Right.
All right. So here is the veil that everybody seems to think doesn't really occur. So even if charges are brought against the applicants, they're prosecuted, they're found guilty, it still literally does not deny their workers' compensation claim. It is a very interesting aspect of it, especially if it's like collecting TD while working. That still doesn't mean that they weren't injured at the job and they're not entitled to permanent disabilities. That is probably the most frustrating part, especially on these cases. My case with the woman was working or volunteering at the tea shop and they prosecuted and got a conviction. I still had to settle that case. So very frustrating from the employer's perspective if it's not a fraud per se on the actual injury. So it doesn't eliminate the need to further continue with the applicant's claim. Generally on denied claims, I feel as though it's a pretty good chance to settle the case pretty early, but on those accepted claims, I don't think it eliminates our responsibility.
So Brent, can I jump in on that real quick?
Yeah.
So in cases where I would say 80% of the cases that I submit for prosecution are settled. So the defendant will enter a plea of guilty in exchange for some sort of negotiated plea. And typically what we're asking for, almost every time, I would say, what we're asking for is a withdrawal of their claim with prejudice in order for us to accept any sort of guilty plea from them. So we'll do that up front. My understanding is that is helping the insurance company if they were to withdraw their claim with prejudice, so as to, obviously the employer removes it from the X-mod, and then the insurance company doesn't have to continue litigating the claim, I think.
Well, I mean, if they enter into a withdrawal with prejudice, then yeah, they can. It's pretty much a slam dunk. It's those, dismissals without prejudice that tend to come back sometimes that people don't realize. But on my particular cases, 2 of them were denied cases. I settled them both instantly for like $1,000 to make them go away. And then the other one, like I said, we had to actually go to court and get a judge on a finding. It was a low-level disability case anyway. But yeah, I think everybody, that is the end of the presentation. I realize that This is a webinar and it will be recorded. You can watch it again if I talk too fast. I do apologize though that it's not a more interactive one-on-one session. So my contact information is on here. You can email me. My email is brent@blackandrose.com. Spell out the word and. If you have any questions that you specifically want to ask me, I'm more than happy to answer them. Carlos probably has a few questions. We still have a little bit of time here, but I just wanted to throw that out. And I definitely want to throw out, thank you, Adam, so much. Thank you, Chris, so much. Thank you, Carlos. Everybody coming on here today. It was a really good, great collaborative effort. So I really appreciate that.
Well, job well done to all you speakers. Absolutely. Thank you so much for the time that you took to prepare it. Sorry, did I cut somebody off? Okay. So I do want to share the results from our poll for unmanned surveillance, which I think is really interesting. So if you look at your screen, you'll see here, 23% of you that voted said, yes, of course, I use unmanned surveillance. AI eyes never lie. 48% of you said sometimes, but I feel like I'm in a spy movie. And then 32% of you said, nope, I prefer the old-fashioned binoculars and coffee method, which is great. I have a question for you panelists. And while I'm doing this, I'm going to try and multitask here. There was a very interesting question from one of the attendees that asked, can you conduct surveillance if a claim is not litigated? What are your recommendations on that?
They're a pro per, they don't have an attorney or anything like that. Is that probably what the question is? You can always get surveillance on stuff like that. Generally, those claims don't come to our office if they're not represented by an attorney. Generally, that's more something that the adjuster and investigator may do on their own. But yes, you can absolutely still do that. You know, if they are unrepresented, they haven't filed an application, there's no ADJ number, it makes things a little bit more difficult. For example, no depositions, you can do statements under oath. They're not really as admissible. You could still do it, but it just does make it a little bit more difficult as far as presenting it.
Yeah, and to amplify on that a little bit more, because we get engaged in those matters very frequently, where the claim is accepted and we're still conducting surveillance. And usually the question that comes attached to that is it even legal for us to do surveillance, on a claim that it's accepted and, we're still looking to verify something. And the general answer is yes. I mean, you can conduct investigation on any claim if you need to verify the claim, right? There doesn't necessarily need to be a level of fraud or suspected fraud at that point. But if you need to verify information, you got to keep in mind that claims administrators have a statutory requirement to investigate claims and handle them fairly. And so as part of that good faith process, you're going to have to conduct investigation and then determine, is this person really injured to the degree that they say they're injured? Are they somewhat injured, but not too much? And then that would allow you to apportion the claim. Maybe that would decrease the permanent disability percentage of that claim. So you're still utilizing it proactively to mitigate the overall cost. And then if and when, the claim does become litigated or there's some sort of misrepresentation uncovered, then that's when it starts escalating into more of a full SIU component, where now we're not just using the surveillance, but we're also gathering statements. We're also collecting other evidence in anticipation of them submitting a package to the district attorney's office. And then even then, it's very important that I would say that SIU even engages the district attorney's office even before submitting that package. If you think that you have something going on, I always love the idea of, pick up the call, right? Call Adam and be like, hey, Adam, this is what we got. It's right in your back door. We're still working on it, but I'm just wanted to kind of, pick your brain and run some ideas with you. This is what's going on. What do you want to see from a DA's perspective, on our end, as we're kind of carrying on with the SIU investigation? And Adam would sit down and be like, hey, what you have here right now, like, I want to see more of this evidence. I want to see this. I want to see that. I want to see that. Come back to me once you have that information. And then, we'll probably be ready to take it on at that point. And that just, that collaboration component not only expedites things, but it prevents, having the DA denying the package, spending all that time and then just rejecting it because, there's insufficient evidence.
Great advice, Chris. Thank you for that. Doing a time check here. We have about 8 minutes left, and I've got a couple of questions that I definitely want to get in front of you guys. So kind of rapid round here, okay? This question is regarding self-insured public agencies. So how do you ensure that your claims administrator is effectively investigating claims utilizing the tools that you all have discussed today? Specifically, or especially rather, that over 90% of claims are being accepted. What are your thoughts on that?
I mean, if the claim is referred over to us, for example, it's just making sure that you just want to make sure that on the front end of those claims that you're doing the right things during the initial sort of phase of accepting the case, right? Like you want to make sure that there's no contrary information in the beginning. For, public agencies, self-insured, it's just important to make sure that the adjusters are gathering the information and then maybe asking an attorney. Like you may not even have to refer it over, but asking an attorney, what do you think of this? Like, do you think there's enough here that sort of sparks the need to maybe to even do a social media background check?
Yeah. And to amplify it on that a little further, I think it has to do a lot with strategic partnerships as well. Is, realistically, per, statistics of the National Insurance Crime Bureau, only about like 10% of claims actually have a fraudulent component. It may be more or less during certain, seasons or certain things like COVID, but in general, about like that 10%, that's when you're going to start seeing, some elements of that. Going back to that particular question, Carlos, if the claims administrator is not investigating the claim, I think it's understanding the reason. There are reasons as to why they're deciding not to investigate it, and then engaging, your service providers. For example, we do that all the time with some of our public entity clients, where they'll come and say, hey, the administrator, the claims administrator is now wanting to investigate this. Can you do an independent kind of review of the claim and just see if there's anything there that would warrant further investigation? We may look at the information in its totality and agree and say, you know what? Yeah, at this space, it does not seem like further investigation is warranted. But then we may disagree and say, you know what? I think the adjuster might have missed this information here. Based on this, it looks like there's sufficient red flags that would warrant further investigation. And then at that point, again, keeping in mind that claims administrators do have a statutory requirement to investigate, questionable claims. So at that point, that's probably going to result in an investigation at some degree to verify the information, or if there's more information that ensues that contradicts, what was initially claimed, then obviously the investigation will start expanding more as the claim progresses.
Next question is, what has your experience been with high dollar claims that have already CNR'd, and there is information that the PD was way higher than alleged? Have you been able to get them overturned?
Those are really difficult. I have not on a CNR, on a stipulation with request for award. I have. The permanent disability was really high. We had some post-surveillance, and we ended up on a stip and award, and we ended up sending it to, it was an AME doctor actually, and the AME doctor definitely provided a contradiction on the permanent disability. We caught it close up front. So luckily the permanent disabilities weren't paid out all the way. So we were able to mitigate that one. CNRs are tougher because, the argument is, unless you spell out in the CNR, which we definitely try to spell out in the CNR, how much of the settlement is permanent disability versus future medical care, it's a tough claim. The permanent disability is $20,000, but the medical care is $70,000. And what are you mitigating? You trying to mitigate the future medical care. So those are a lot harder.
Next question is there any benefit to setting a standard of social media or background type of investigations on all claims, so you're ahead of the curve if something does get litigated?
Yes, the good old Zach Brown question. I saw that one. Go ahead, Chris.
Yeah, absolutely. There's a ton of benefit, and there's several clients of ours that do that as best practice. I think it's a proactive approach where, if you're conducting, a cursory social media background check on the claims that are being submitted, it shows that you're being proactive in verifying, the information that's being reported to you, but it also increases the probability of you uncovering information that may contradict that, then further ensuing, investigation early on when people are not represented yet, when, people haven't made their accounts private. So from an SIU standpoint, it allows us to engage those people immediately, start talking to everybody, lock them into a version of their story, start collecting all that social media information so that if and when it becomes litigated and it starts escalating, everybody's going to start shutting down. And now the attorneys are going to get involved, and, Brent's going to have to do his thing. And then Adam's going to have to go knock on people's doors on the weekend. And it's, we don't want to have Adam on the weekend out there, so definitely early intervention. It's great.
I caught that too, Chris. I caught that too. He's like, I'm going to the doctors at the weekends. I'm like, man, he's committed.
He definitely
Guys, here's another great question, very insightful. How is surveillance meaningful for musculoskeletal injuries? For example, mild TBI cases.
They can be more difficult. You have to show what correlation you want to whatever the injury is. I mean, if I have somebody who had just a straight psychological injury and they're claiming they don't do anything and they can't do anything, but I have surveillance of them going out to dinners with friends or going to church and participating in things of that nature, it mitigates those types of claims. It really depends on the type of claim and what you're looking for. I have a case right now. We're getting great surveillance. I feel like I don't think it's showing the guy doing a lot of physical activity, but he has a neurological injury to his brain. So what is the video really going to show as far as that aspect? So you just really have to hone in on what the actual injury is and if it's, good surveillance for that type of injury.
Adam, how frequent are you seeing those side claims on your end? And like what type of evidence do you feel prevails in being able to get a successful prosecution, if at all, on those type of files?
So site claims, you're going to need if you have video for a site claim, you're going to need to contextualize that video with questions that say, within the last 6 months, apparently your psych injury is causing you to not be able to spend time with friends or loved ones. Within the past 6 months, how many times have you seen your friends or loved ones? And they're on video with their family. Then you have a material lie. However, most of our psych cases that we actually prosecute are always dependent on having prior psych injuries going into their current psych claim. And so that is done with subpoenaing prior medical records to show they already had a psych injury. And then when they reported to the doctor that they've developed this new psych injury, they say that, they've never had other psych symptoms before. So everyone that we've prosecuted has been essentially an apportionment related psych case.
Excellent. Last question, guys, and then we'll wrap it up here. Is there a way, or maybe a checklist already exists, of the key documents and evidence an employer should gather to successfully investigate and prove fraud in a workers' compensation claim?
It's a lot of documents, and it's going to depend a lot on the type of claim, on the type of allegations being made. I mean, it's all about what is materially relevant in that particular matter. We do have a general kind of one pager that lists the type of stuff that as an employer you should be gathering early on. That would help, an SIU investigation, and eventually, if it's submitted to the DA's office. So after this, we'll send that over, Carlos, and then we can distribute to everybody here for reference. But that list is not going to be a totality list. It's really going to depend on a lot. So the best answer to that is always engage your service providers, your attorney, your SIU provider. Have that conversation of what is going on with that claim, even if it's early on and it's not litigated yet and it's in the initial phase, and then just engage the experts in that matter. Let them kind of guide you on like, hey, this is the stuff you should be looking for. If it does escalate to a certain level, get us engaged, and then we'll escalate it further. That's usually going to be the best way of going about that.
All right, everybody. Guys, thank you so much. Again, it's been great. Appreciate everyone logging in and interacting. Thank you.
Thanks, everyone. We'll see you on the next one.